Members of the House, this motion is a little bit unbelievable in the sense that it suggests that we should be setting the attorney's fees, even though the amount that the gentleman is asking us to set far exceeds what would be ordinary hourly wages fees in these kinds of cases across the nation. At the same time, it makes no differentiation for geography, complication of cases, a number of attorneys are necessary in a case, or even the number of firms that may be. We don't know if this applies to all of the attorneys in a case with multiple plaintiffs, whether this applies across the firm if multiple attorneys are in a firm on a single case, if it's a complicated case, and in many cases these are very complicated cases because they go in to business practices that are disguised in terms of trying to justify unequal pay in the name of equal pay. I find it rather interesting that the supporters of this amendment across the aisle all stood up and talked about how they support the idea of equal pay, how they want their daughters and their granddaughters to be treated equally, how they want to make sure that they're treated fairly in the workplace, and they really support the concept. They just don't support this bill, which would make that the law. But then what did they decide to do? They decided when those granddaughters and daughters aren't treated fairly in the workplace, they will discriminate against them in an ability to have an attorney. They will discriminate against them because they will say that their attorney's fees are going to be capped according to this law, as opposed to letting the judge and the court work out what are reasonable fees in that court case. Why did they discriminate against them? The gentleman's jumping to his feet because there's no cap on the attorney's fees of the people who discriminated against them. On the employer who made the conscious decision to pay this person less in the workplace, to treat them in a discriminatory fashion, to not recognize their inherent value and the comparability of their skills and their talent. I will not yield. I'm on my time. They've decided that those employers can pay $5,000 an hour, $25,000 an hour, or $250,000, and they can hire as many firms as they want, New York firms, Chicago firms, Los Angeles firms. They can do whatever they want. But your daughter, granddaughter, wife, they're limited. They're limited in what kind of legal talent they can get. How about in the large case in this country today where regional vice presidents, there's 39 of them in the organization, 10% of them are women. The men were paid $41,900. The women were paid $27,900. The district managers, the men were paid $23,900. The women were paid $17,000. You think you ought to have the right to go to court and have a good attorney and have the court determine what are reasonable fees? You ought to be able to prosecute your case in the face of an employer that may have multiple law firms on permanent retainer to deal with this, as many of these defendants do? Yes, I think you should. And so do the people of this country, and I hope so do the members of this Congress. And I'd like to yield to Mr. Andrews, the subcommittee chair.
If the Securities and Exchange Commission filed a civil suit against one of the people accused of the Wall Street wrongdoing, and there was a proposal on this floor that said the SEC can spend as much money as it wants to on its side of the case, but the Wall Street defendants accused of the wrongdoing are capped on how much they can spend on their legal defenses, I think the members of the minority would say that's unfair. It is. So is this. To interfere in how much lawyers are paid is a matter the judges should take a look at under this law. It's not something this Congress should interfere with, and it frankly, I believe, is a diversionary tactic to take us away from the real purpose of this law. And that's a woman that is selling real estate or teaching school or sweeping floors should make penny for penny, dollar for dollar, everything a man makes to do the same job. That is the issue before the House. Let's defeat this diversionary amendment. Let's pass the underlying bill and bring long-awaited justice to American women. I yield back to the chairman.
I ask my colleagues to reject this amendment, to keep the purpose and the intent and the constitutionality of the underlying legislation, and that we should now pass, after many, many years of waiting, pass the Paycheck Fairness Act. And I ask a no vote on this, and I yield back the balance of my time.